I'm Tim Longman. I'm the director of the African Studies Center here at BU, and it's my pleasure to welcome you all here to this event that involves a number of co-sponsors and has been organized fairly quickly, surprisingly quickly for an event this large, with the particular organization of the Center for Finance, Law, and Policy. The other co-sponsors are the School of Law, the Center for Global Health and Development, and the African Studies Center. As somebody who has participated in a variety of war crimes trials, mostly involving Rwanda, where I specialize, and has testified at the International Criminal Tribunal for Rwanda and at trials in the United States and Canada and Finland, I'm particularly pleased to have the opportunity today to welcome our speaker. I'd like to say particular thanks to the people who worked to organize this event before I get started. And I will tell you a little bit about the lecture series that this is part of, and then I will turn it over to the Dean of the Law School to introduce our speaker. The primary organizing for the event was done by the Center for Finance, Law, and Policy, and there's a particular thanks go out to Neil Esty and Jaho King, who really did the major work on this. Can you raise your hand, say hi? And Matar, I don't know your last name, Matar, I realize. Matar Juf, oh, okay, that's a good West African name. So Matar Juf, who actually made the main connection with our speaker today and has actually, is a student of the School of Law, but has been helping out at the Center for Finance, Law, and Policy. I'd also like to thank Joanne Hart and Peter Quella from the African Studies Center for the work that they've done in helping to organize the event today. And I should mention that immediately following the event, there will be a reception across the hall, which you're all welcome to come attend and have a chance to speak with our guest lecturer one-on-one, or 200-on-1, as it were. Our lecture today is a particularly fitting topic for the annual Morse lecture. The F. Bradford Morse Distinguished Lectureship at Boston University was established through the generous support of the Industry Council for Development and has taken place annually since 1989. The lectureship was created in recognition of the contributions of the Honorable Bradford Morse, who was a Republican congressman from Massachusetts for 6 terms until he resigned to accept an appointment as Undersecretary General of the United Nations in 1972. From 1976 to 1986, Mr. Morse served as the head of the United Nations Development Program, which, as many of you may be aware, is an agency that's played a key role in supporting economic growth in the developing world, including sub-Saharan Africa. From 1986 to 1991, Mr. Morse served as president of the Salzburg Global Seminar, which is a nonprofit organization based in Salzburg, Austria, whose mission is to challenge current and future leaders to develop ideas for solving global problems. He passed away on December 18th, 1994, at the age of 73. This lecture series was set up to bring in scholars, particularly who work on Africa and who can speak to issues of global affairs. And so our speaker today is really fitting very well within that tradition and very much honors the work of Mr. Morse. Our speaker will be introduced by Dean Maureen O'Rourke. She's been on the faculty of the BU Law School since 1993 and has served as dean since 2006 after serving 2 years as dean ad interim. She received her BA from Marist College and her JD from Yale University. So let me turn it over to Dean O'Rourke.
Thanks, Tim. It's a great pleasure for me to be here for this presentation, which has, as Tim mentioned, been organized by the Center for Finance, Law, and Policy. The center is led by the professor of the practice of banking law, Con Hurley, who unfortunately couldn't be here with us today. But the center that he has put together plays a critical role in analyzing and recommending solutions to the financial, regulatory, and policy challenges that impact the national and global financial system and the world economy. And there's no question that the world economy plays a major role in the tactics of various leaders around the world. This afternoon, we will hear about the role of the International Criminal Court in advancing security, dignity, and growth around the world. The ICC is the first permanent treaty-based international criminal court established to help end impunity for the perpetrators of the most serious crimes of concern to the international community. Our distinguished speaker is Fatou Bensouda, the new Chief Prosecutor for the ICC. Since Mrs. Bensouda assumed this position last year, the ICC has issued arrest warrants for Muammar Gaddafi's son and brother-in-law. Both have been charged with murder, persecution, and crimes against humanity in Libya. The ICC has also opened a case against Joseph Kony and the top 4 members of the Lord's Resistance Army in Uganda. They are charged with a list of heinous crimes, including enslavement, rape, pillaging, and forced enlistment of children as soldiers. Mrs. Bensouda, who will be responsible for prosecuting these cases, previously headed the legal advisory unit at the International Criminal Tribunal for Rwanda. She was later elected deputy prosecutor by the ICC's Assembly of States Parties. Between 1987 and 2000, Mrs. Bensouda held a number of increasingly responsible government positions in her home country of Gambia, eventually becoming the nation's Attorney General and Minister of Justice. She has been a delegate at UN conferences on crime prevention, the Organization of African Unity's ministerial meetings on human rights, and meetings of the ICC's Preparatory Commission. It's my great honor to introduce Fatou Bensouda.
Thank you very much. Thank you. And thank you for having me. My particular thanks goes to Matar and also to the Center for Finance, Law, and Policy for inviting me to give this lecture. It is an honor for me to address this audience this evening. And today I would like to share with you some reflections on the International Criminal Court, a unique institution that I still have the privilege of being the deputy prosecutor since 2004, as well as the next prosecutor starting June 15, 2012. And I would like to discuss with you today how the work of the court can contribute to the prevention of massive crimes and to help bring more peaceful and prosperous societies. I would like to discuss with you how the preventative impact of the court's work could be maximized. How can we bring reconciliation in the Ituri region of the Democratic Republic of Congo? How can we pacify the Kivu provinces of the Democratic Republic of Congo? How can we prevent a new cycle of violence during the next elections in Kenya that is scheduled for 2013? How can we support Colombia's efforts to end half a century of violence? And I will just say one word, and that is institutions. In our countries, the Congress, the police, the prosecutors, and the courts are the basic institutions to establish and enforce law and order. The Rome Statute, which establishes the International Criminal Court, is building the same idea internationally. Judicial institutions are created to contribute to prevent and to manage massive violence that threaten the well-being of the world. Let me recall that 60 years ago, with the Nuremberg trials, for the first time, those who committed massive crimes were held accountable before the international community. And for the first time, the victors of a conflict chose the law to define responsibilities. And Nuremberg, we all know, was a landmark. But at the same time, we have to recall that it would seem the world was not ready to transform such a landmark into a lasting institution. And in the end, the world would wait for almost half a century and would witness again 2 genocides, first in the former Yugoslavia and then in Rwanda, before the United Nations Security Council decided to create the International Criminal Tribunal for former Yugoslavia and also the International Criminal Tribunal for Rwanda, and in so doing, connected peace and international justice again. And these are the ad hoc tribunals, and they have paved the way for the decision of the international community to establish a permanent international criminal court. And this was mainly done to avoid a repetition of its past experiences. This court, the ICC, is built upon the lessons of decades of unimaginable atrocities that deeply shocked the conscience of humanity, decades when the world had failed to prevent massive crimes. And it shows how innovative an idea it is to have international justice. It is only with the Rome Statute establishing the International Criminal Court that the international community added an independent and permanent justice component to its efforts to achieve peace, security, and stability. And the Rome Statute establishing the ICC offers a solution, creating global governance without a global government, but with international law and courts. Accountability and the rule of law provide the framework to protect individuals and nations from massive atrocities and to provide for safe societies where human rights are respected. The ambassador of Costa Rica once explained, the ambassador to the United Nations, he once explained why his country was so active at the Security Council on the issue of Darfur, Costa Rica and Darfur. And he said why Costa Rica had to show leadership on an issue apparently so far from its interest. He explained it by saying, there are 26 countries with no armed forces in the world today, and Costa Rica is the biggest amongst them. Thus, for Costa Rica, promoting the rule of law internationally is a matter of domestic security. In 1998, this idea of creating an international criminal court was an idea on paper. In 2012 today, we have put this idea in motion. The International Criminal Court has become a recognized institution that is part of the international landscape. And the efforts of the international community to preserve human dignity. Ladies and gentlemen, allow me to give you a proper understanding of how the Rome system is put in motion and what its contribution can be to societies across the world. One of the main principles of the Rome Statute is that all states parties commit to investigate, to prosecute, and to prevent massive crimes when perpetrated within their own jurisdiction. This is what states parties have signed to. And today, 121, with Guatemala just joining last week, 121 states today have accepted that. Should they fail in this primary responsibility to investigate and prosecute, the ICC can independently decide to step in. This is the principle of complementarity. And under this principle, proceedings before the ICC as a court of last resort should remain an exception to the norm. It is with this in mind that the Office of the Prosecutor has adopted a positive approach to complementarity, which means that the office encourages genuine national proceedings wherever that is possible. But this does not mean that the office will be involved in providing direct technical assistance or capacity building, as the office is not a development agency, and these are the tasks that are best reserved for other competent bodies. There is also statutory limits to the types of activities that the Office of the Prosecutor can be involved in. It will not be directly involved in providing legal advice, as such action could risk tainting future ICC admissibility proceedings. Nor can the office provide information without ensuring that there is proper security standards and national authorities are willing to receive such information. What the office has been doing, is to make public announcements of the beginning of a preliminary examination into a situation, meaning a country in conflict where these crimes are taking place. We also send missions. We also request for information from national governments about their efforts to end impunity. In fact, just couple of days ago, I'm coming from Guinea, which is a situation under preliminary examination, and perhaps during the question and answer, we can talk about that. But the information that we get, can be factored in by all the states and relevant organizations in order to promote accountability in a timely manner at the national level. In Colombia, for example, the prospect of the court, the ICC, exercising jurisdiction was mentioned by prosecutors, by the courts, by legislators, and by members of the executive branch as a reason to make policy choices in implementing the justice and peace law, and by so doing, ensuring that the main perpetrators of crimes would be prosecuted. It has been widely reported that the office's preliminary examination of the situation in Colombia served as an incentive to the Colombian authorities to fulfill their primary responsibility to investigate and prosecute crimes that fall under the jurisdiction of the ICC. And in so doing, the office has consistently encouraged and monitored the Colombian authorities to bring the perpetrators to account, and including through the Justice and Peace Law that was adopted in 2005 with respect to the paramilitary leaders. National proceedings have been initiated against guerrilla groups, police and army officials, as well as politicians who had alleged links to the armed groups. And there is also investigations in Colombia going on into the so-called false positive cases. Also, following the opening of an investigation into a situation by the Office of the Prosecutor, positive complementarity continues to inform our policy towards the selection of our cases. Situations under investigations by the Office of the Prosecutor will typically involve a large number of massive crimes committed by numerous perpetrators against scores of victims. And pursuant to this policy of focused investigations and prosecutions, the office, it is our policy to investigate and prosecute only those who bear the greatest responsibility for the crimes. Focusing on this most responsible is the way that we think we'll be able to maximize the preventive impact of the court's intervention. And it is always up to the states themselves to deal with the other perpetrators. All the cases that are presently before the ICC have been against the top leaders of the organizations involved in the commission of crimes, including 3 heads of state. Following this specific duty also to focus on gender and crimes against children, the office's first case against Thomas Lubanga Dilo who was found guilty just on the 14th of March, 2 weeks ago, the case exposed how boys and girls were abused as child soldiers, how they were trained to kill, how they were trained to rape, and how they themselves were raped. And each subsequent case that we have has highlighted the further aspects of gender crimes, from command responsibility asserted for an organized crime campaign of rapes in the case against Jean-Pierre Bemba. As some of you may know, Jean-Pierre Bemba is a former vice president of the Democratic Republic of Congo, and he was charged with crimes that took place in the Central African Republic. From that case to the charges of genocide through rape against President al-Bashir of Sudan in Darfur, the gravity threshold of all these cases is very high. And in each situation, there are hundreds of thousands of persons killed and raped. And in many, there are millions of persons displaced. The cases before the court are indeed the most serious crimes of concern to the international community. And accordingly, the Office of the Prosecutor supports a comprehensive approach to combat impunity and the prevention of recurring violence. We do this by combining our own efforts on the most serious and on those who bear the greatest responsibility, while at the same time trying to encourage and support national investigations and prosecutions for the other perpetrators, as well as even truth and reconciliation mechanisms. We may, for example, provide national authorities with information. This information is one that is collected by the office that could be of assistance to the national proceedings, subject, of course, to the existence of a credible local system of protection for judges and witnesses, for the integrity of the proceedings and other security caveats. The office of the prosecutor may also share with national authorities expertise in relation to its best practices in the conduct of investigations and prosecutions, including witness protection and evidence handling. In Uganda, for instance, in addition to the office's investigations, as I'm sure some of you may know that we had the Uganda case since 2005, and Joseph Kony, the Lord's Resistance Army chief, has been indicted by the ICC since 2005. He was indicted together with four other commanders. Now 2 of them have died, and the ICC warrants are still outstanding against Joseph Kony and these top leaders. And in our investigations, in addition to what the office has done, we have also been providing assistance to the national authorities, that is Uganda, to investigate and prosecute an LRA commander who was arrested in the Democratic Republic of Congo. The charges included some incidents that in 2002, we had already investigated by the court. And the office was able to provide this information to the Office of the Public Prosecutor in Uganda. We were able to give them material. We were able to give them transcripts of taped intercepts, because we've been intercepting their conversations, searchable records of handwritten logbooks of various maps and graphs. And Uganda has also requested our office to provide assistance with regards to witness-related issues. And in more general terms, to contribute to national efforts to bring expertise and capacities and foster economic well-being, the office is in the course of, or has developed contacts with World Bank, the Bureau for Fragile States, the UN Peace Building Commission, the United Nations Development Program in the DRC, the various special representatives of the United Nations Secretary General, as well as with donors, to inform them of the specific needs of such countries which have come to our attention. As I said before, we cannot do it because we are not a development agency. We don't have the mandate, neither do we have the resources for it. And we are doing this because the goal is to encourage the international community, including the donors, to accept a policy or adopt a policy of promoting peace and justice and reconciliation efforts which effectively complement the work of the ICC. We also provide information about the judicial work to those involved in mediation efforts, such as the United Nations, and also to even special envoys, in order to promote comprehensive solution to conflict situations, including ensuring accountability. One area that I would particularly like to highlight here is education. Education as one of the fundamental means to maximize the contribution of the court to the prevention of future crimes. The crimes that have been committed by Thomas Lubanga, I talked about the first case of the ICC, are the crimes of conscripting and enlisting children under the age of 15 and using them to participate actively in hostilities. This highly impacted on the children's right to education. In fact, according to a report from the NGO Education for All, this was published by UNESCO in 2011, 28 million children of primary school age in conflict-affected poor countries are out of school. And these children need to be included in the education system. The Lubanga verdict is an opportunity to focus on how both states and other relevant actors can contribute to justice through the national education curricula. This interest is the interest of the Office of the Prosecutor was expressed, we've already expressed it in our prosecutorial strategy, which was for 2009 to 2012. And the aim is to encourage the inclusion in students' curricula of information about past conflicts, about global issues such as child soldiers, and how the functioning of this institution can assist. Ladies and gentlemen, the message that I am essentially trying to convey to you today is that the true relevance of the ICC trials, as well as other activities of the ICC, will lie on the fact that by their global impact, they can contribute to the prevention of recurring violence and thereby help to contribute to more peaceful societies. One court ruling by the ICC affects a multiplicity of cases. And that is what the United Nations Secretary General Ban Ki-moon has referred to as the shadow of the court. And this shadow should be considered as the most important impact that the court can have. And what is the shadow of the first trials of the ICC? Our trial against Thomas Lubanga, I come back to it, has helped to trigger debates on child recruitment in remote countries like in Colombia, also in Sri Lanka. And in fact, child soldiers were released in Nepal, about 3,000 of them after the beginning of the Lubanga case. And the special representative of the children in armed conflict immediately has factored in such a potential and has used it as a tool to campaign for the release of more children. And this is an example of how to use the law to prevent crimes. The Lubanga ruling, we believe, will change the life, or has the capacity to change the lives of boys and girls. Never again should they be left out of the assistance provided by the demobilization programs. Never again should they be used as fighters or as sexual slaves. In the second trial of the ICC, the prosecutor versus Germain Katanga and Matthew Ngujolo Chui, for which the oral arguments, the closing arguments, will be made on the 15th of May next month. And the closing of this trial, this is a trial that focuses on the militia group that was fighting against Thomas Lubanga, also in Ituri. We hope the closing of this trial will also bring further accountability and reconciliation in the Ituri region of the Democratic Republic of Congo, and will also further contribute to the pacification of this region. In our third case, I've already mentioned the case of Jean-Pierre Bemba. The Office of the Prosecutor has finished presenting its evidence. We finished on the 20th of March last month. And also, this is the first time, this case is the first time for the international criminal justice system to address a situation where the allegations of sexual crimes outnumber the allegations of killings. It is the first trial before the court that concerns command responsibility. A commander, whether of regular army or militia, the failure of a commander to act can result in unimaginable atrocities that can deeply shock the conscience of humanity. And in this case, the case of Jean-Pierre Bemba, we are alleging, and the evidence we presented, we are asking the court or telling the court that Jean-Pierre Bemba has failed in this responsibility to stop and prevent his militia from using rape as a primary weapon of war. And in terms of impact, we believe this trial is an opportunity. Like any other criminal court, of course, the responsibility, the individual criminal responsibility of Jean-Pierre Bemba will be decided by the court. But the aspect, the preventive aspect of this trial, its forward-looking aspect, has no precedent. Unlike any other court, the ICC's decision will influence, we believe, the behavior of thousands of military commanders, at least from the 121 states parties today, including, of course, on the African continent. I'll just give you a final example before I conclude. It's the cases of the ICC that relates to prosecutions in Kenya. In Kenya, we had brought charges, and they have been confirmed against 4 out of the 6 suspects. The trial of this case, we believe, will help to support the structural reforms in Kenya, and hopefully also will help to prevent violence during the next presidential elections. We hope that they will serve as a deterrent in other presidential elections across the world, including political leaders putting them on notice that if they use massive violence to gain or to retain power, whether within or outside of elections, they will be prosecuted. We can see the effect of the court's activities in practice. But let me conclude, ladies and gentlemen. I believe that the world today increasingly understands the role of the ICC. The court's activities we see are affecting the behavior of governments and of political leaders. And we have seen that armies around the world are adjusting their operational standards. Conflict managers, peace mediators are refining their strategies, and they are doing so taking into account the mandate of the ICC, also respecting the legal limits. And even people who are involved in development programs are picking up the lessons of the court. The Rome Statute, therefore, is extending, it's building a network across the world to maximize the prevention of massive crimes. In Rome, I come back again to Rome because that is when, in 1998, the ICC was established. In Rome, the states made a conscious decision to create a justice system that could stop or prevent violence rather than just these ad hoc tribunals that are created after the fact. New rules were created, and other actors must adjust to these new rules. It provides, I submit to you, it provides an opportunity, and its real success, the success of this system, will all the time depend on the efforts of the international community to capitalize on this. And thank you for your patience.